My name is Eric Traben. I'm a former state of Florida prosecutor. Currently, I'm a private criminal defense attorney serving throughout Central Florida. What I'd like to talk about today is something called first appearances. Florida law requires in all criminal cases that if someone is arrested, that they be brought before a judge within 24 hours of that arrest. Now, most cases in Florida, when someone is arrested, they're what are called on-site arrests, meaning a police officer might catch someone allegedly doing something and they arrest them on the spot. These are the DUI cases, drug cases, marijuana, cocaine, heroin, domestic violence cases, cases where there's a warrant that a judge issues in advance or charges already get filed before someone gets arrested, generally are not subject to first appearance rules. The point of a first appearance is that if the police officer just arrests someone and it hasn't yet been approved by a judge, right, there's no warrant or charges haven't been filed yet, it has to get reviewed by a judge to make sure that that person is being held based on a finding of probable cause. That way people aren't just being swept up by the government and held for no reason whatsoever. It lets the judge supervise what the police are doing. Probable cause is a pretty low legal standard, but it basically means that it's probable that a crime was committed and the person that's accused is the one who did it. Certainly not proof beyond a reasonable doubt. It's not even more likely than not. It's a pretty low standard. And so it's not uncommon for a judge at first appearance to find most cases for there to be a finding of probable cause. But what happens is every single person that gets arrested in Florida has to be brought to a judge within 24 hours. So what that means is if someone gets arrested and it's midnight or 1 in the morning, in all likelihood they'll be seeing a judge first thing in the morning at 9 a.m. where the judge reviews the police report or any affidavits, signed statements, sworn reports that they have, and they make a determination based on that document only whether there's probable cause. It's not the time to actually argue the merit of the case, to say, oh, they're lying, or let me tell you my side of the story. Rather, it's really just a time where the judge looks at the paper and looks what's sworn on there and treats it as if it's true. And the judge looks at it and says, based on this, is there probable cause? And if there is, then they make that determination and they say there is probable cause or I find probable cause of the offense charged. If there's no probable cause that's found, then the judge would issue an order releasing that person. It can't be held if there's no probable cause. That doesn't make the case go away. A lot of people are disappointed to find out that doesn't mean the charges are dismissed. It just means they can't be held prior to the case resolving, so they have to be released. Under a showing of good cause, the state can get additional time, usually just 24 hours, to obtain additional evidence to show probable cause. But in most situations, if there's not that showing of probable cause at the first appearance, that literal first appearance, then the person is ordered to be released. On the other hand, if there is a finding of probable cause, then the judge will usually issue a bond. A bond is literally a payment of money to the jail or the government to guarantee that a person is going to show up for court later on. If they don't show up for court or if they get arrested for something else, they forfeit that bond. They lose that money. And so it's kind of the incentive to make sure that people follow the rules while they have a criminal case pending. The Florida Constitution actually provides people to have a right to a reasonable bond. So in most cases, judges will order a bond that is supposed to be reasonable, meaning that a person could realistically afford it. In all cases where a bond is issued, a person can either pay the bond directly out of their own pocket with cash, or they can hire a bail bondsman who pays the bond on their behalf for a fee. When there's a determination of probable cause and a bond is issued, right, a person can make that payment and be released. But sometimes there are some limited scenarios where a person might not be granted a bond. Those scenarios include if they've already been on release and they violated the conditions, been arrested for a violation of probation, meaning they already were sentenced for a crime, were put on probation and then violated it somehow, or if the crime is extremely severe and punishable by life in prison. Crimes like sexual battery, robbery with a firearm, murder, those are crimes that because of their severity and that they're punishable by up to life, may not necessarily automatically get someone a bond. At the same time, there might be a scenario where someone is charged with a serious crime punishable by life, but for whatever reason, the court determines that a bond might be appropriate. And even then, because the answer to every legal question is always going to be, it depends, there are still other exceptions here. One of these exceptions is that even if a person is charged with a crime that's not punishable by life, it might be possible that no condition of release could protect the public from this person. That's a very specific set of circumstances where the state would have to convince the judge that if this person is released, they're going to endanger the public. They're going to be a harm to someone. But in those scenarios, the judge might make that finding and they could continue to order that person to be held on no bond. All of the people that are arrested, as I mentioned before, may already have a bond by virtue of the charges being not punishable by life. Those cases such as, again, DUI, actually DUI is not a good example. DUI cases, people have to actually be held in jail for a certain number of hours as a way of making them sober up. Domestic violence cases require people to stay in jail for 24 hours before they can bond out. That gives an alleged victim the opportunity to move away or get away from that person or obtain a restraining order if they want that. But there are a lot of cases where if someone gets arrested, maybe for a drug charge, where they already have a bond, they can pay the bond as soon as they get to the jail. They don't have to wait and see the judge at first appearance. There are times where someone will be seen by first appearance. Either they get arrested and there's just not enough time to bond out because that process might take several hours. There are times where if a person gets arrested, the jail processes them in a way where they don't have a bond, even though they're entitled to a bond. And that's why it's important to see the judge, who will then grant one, assuming all the criteria is met. And then there are, of course, people who, for whatever reason, insist on wanting to see the judge. Even though they could bond out, they want to wait and see the judge for whatever reason. Perhaps they want to ask the judge to lower the bond, or they really believe that based on the reports, there's no finding of probable cause and they should simply be released. Whatever the scenario is, people still are entitled to have counsel. So at all first appearances, there's going to be an assistant state attorney representing the state of Florida government, and there will always be an assistant public defender from the public defender's office. A person who gets arrested has the right to hire their own attorney, so they can hire an attorney to meet them at the jail and be present for their first appearance, or a person who's in jail can have the right to extend their incarceration so that they can have their private attorney appear on their behalf for their first appearance. But in any event, if someone doesn't want to have to wait or add that delay, they still have a public defender there who's able to handle it on their behalf. So I know that's a lot of information talking about just one little thing at first appearances. The only thing I would add to that, first appearances are a time for the lawyers to do all the talking. A lot of people, when they're arrested, are going to have a lot of strong emotions going on. They're upset, they're scared, they're worried, they don't know what's going to happen. And they also feel like maybe they've been wronged, that they're the victim, and they want to explain their side of the story. For what it's worth, I promise it is not the right time to give one's own side of the story during a first appearance. Everything is being recorded. Everything is ready to be taken out of context and used against a person. Even though a person in custody has the right to speak and the right to tell the judge their side of things, most of the time the judge will shut them down. Again, not to be rude, but to protect their rights. Just like in another video where we talk about Miranda rights that people are familiar with, you have the right to remain silent. Well, that right to remain silent also applies during the first appearance, and it applies at pretty much every stage of the criminal justice process. So a person has the right to remain silent, they need to exercise it. Even though they might feel really strongly that if only they could tell their side of things, the judge would let them out. The truth is, it never works out to their benefit. They really do need to let the lawyer do their job and advocate on their behalf. If for whatever reason things don't go the way that a person wants it to during the first appearance, there may be future opportunities. And we're going to talk in other videos about bond hearings or adversarial preliminary hearings, trials, and the entire criminal justice process. But there will be other future opportunities to address the things that were expected at the first appearance with a judge later on down the road. So that's it for now. We really welcome any questions or comments from people in the public. So of course, you should subscribe to our channel, Traben Law, on YouTube. Definitely like this video. But you can also contact us by going to our website at www.trabenlaw.com. You can also email me at trabenlaw@gmail.com. And who knows, maybe your question will be featured on one of our future videos.